Salve scettici, vediamo cosa sta succedendo nelle corti norvegesi per quanto riguarda i testimoni di Geova. Presenteremo unicamente la difesa del gruppo dei testimoni di Geova e l'anziano che sta parlando in corte si è battezzato a 13 anni, non a 30 anni. Purtroppo abbiamo utilizzato la traduzione automatica che comunque è capibile, ma fateci sapere nella sezione commenti se non avete capito alcuni passaggi. Comunque il canale ripresenterà questa deposizione in futuro con una traduzione corretta. Ricordiamo che il gruppo dei testimoni di Geova ha solo perso le agevolazioni fiscali nello stato norvegese, ma il gruppo è libero di svolgere le proprie attività religiose e di professare la propria fede in tutta libertà.
I see that you will start with giving introduction about the organization you represent. But could you also tell us a bit about yourself and what position you have and background?
Yes, my name is Ben Elder. I currently live in Germany, originally from Scotland. My background is I've been one of Jehovah's Witnesses for probably longer than I remember. I was baptized when I was about 13. And currently my role is I'm director of an office called the Freedom of Worship office that's based in Germany.
I didn't quite get the name of the office. The director of
Freedom of Worship.
Freedom of Worship.
And in conjunction with that, one of my roles is a representative of the European Association of Jehovah's Witnesses.
Okay. Do you have a legal background?
I don't.
You don't. What kind of professional background do you have?
The role I have is a director of this office, so an office manager.
Yeah, but you have an educational background?
I was a tradesman, actually, in building.
I do not.
Your Honour. The European Association is grateful for the opportunity to intervene in this case. The association represents the human rights of nearly 1.5 million Jehovah's Witnesses living in the 46 member countries of the Council of Europe. It is registered with the Charity Commission for England and Wales as a charitable body that considers and responds to threats or apparent threats to religious freedom, particularly in Europe. Now, we want to express our grave concern with the decisions of the county governor and the Ministry of Children and Family Affairs to deprive Jehovah's Witnesses in Norway of state grants and, most importantly, registration as a religious community. So first, I'd like to provide the court with a brief comment on the European context in which the Norwegian government's actions are taking place. Then I would like to address the influence of the Norwegian government's actions elsewhere. And then lastly, I'd give the court an overview of how courts in other countries have handled allegations against Jehovah's Witnesses, allegations which are very, very similar to the ones made in this particular case. So firstly, the Norwegian government's actions must be considered in the historical European context. Sadly, there is a long history of state persecution and hate crimes against Jehovah's Witnesses. But why are Jehovah's Witnesses in Europe especially vulnerable to stigmatization and unfair treatment? Well, historians have concluded that of all religious groups, Jehovah's Witnesses, after members of the Jewish faith, were the most harshly persecuted during the Nazi regime. In other words, Jehovah's Witnesses are a Holocaust victim group. In light of that, how should the state treat such groups? The European Court of Human Rights has repeatedly found that states have a positive obligation to ensure the effective enjoyment of rights and freedoms guaranteed by the Convention, and that this obligation is of particular importance for persons whose views are unpopular or who belong to minorities, since they are more vulnerable to victimization. So accordingly, Jehovah's Witnesses throughout Europe and the world were shocked when they The county governor and the ministry disparaged their entire religious community, alleging that adherents use coercion, intimidation, and that parents employ psychological violence and negative social control against their children. Such sweeping statements marginalize our entire religious community. And these sweeping statements are frequently propagated by anti-cult organizations or organizations actively opposing religious minorities. These comments lead to hate speech and lead to hate crime. For example, comments from just one of the activists regarding this case who attended this court hearing have resulted in their followers calling for the banning of this delusional cult. This is unacceptable in a pluralistic society. I was also deeply concerned to hear how the state's witness from Bufdir explained her views on Jehovah's Witnesses parenting. Is the state implying that some of the religious teachings and practices of Jehovah's Witnesses are somehow dangerous? That parents who are Jehovah's Witnesses should not be allowed to raise their children in their faith? That all parents who are Jehovah's Witnesses are somehow neglectful? That they would deprive their children of love and emotional support? How far could such implications go? Will the Child Welfare Service start to investigate Jehovah's Witnesses and the parents just because they have chosen to follow the Bible's moral code? Well, sadly, European history testifies to what can happen when the state imposes its morality on its citizens using broad and vague laws. In addition, such state action legitimizes prejudice and hatred and even persecution of a religious community. We recently saw evidence of the influence of the Norwegian government's actions elsewhere. Just a few weeks after the county governor's decision to deregister Jehovah's Witnesses, the spokesperson of the Ministry of Foreign Affairs for the Russian Federation, Ms. Maria Zarakova, she used the decision made here to justify the state persecution of Jehovah's Witnesses in Russia. She stated, on December 22nd, 2022, Norwegian authorities revoked the registration of Jehovah's Witnesses as a religious community, citing systematic violations of the law and the unwillingness of the organization's leaders to abandon their legal practices. Interestingly, this principled position does not prevent Oslo from criticizing our country for taking action against Jehovah's Witnesses. It's the same organization, and Russia and Norway are filing similar complaints against it, even though the political response is completely different. The Russian government stated this despite the fact that the persecution of Jehovah's Witnesses in Russia has been repeatedly condemned by the European Court of Human Rights in its judgments of Jehovah's Witnesses of Moscow and others versus Russia, and Taganrog, LRO, and others versus Russia. Also, the ECHR has repeatedly rejected allegations similar to those already made by the Norwegian authorities. For example, in 2010, in the Moscow versus Russia case, this is on page 2964 of the legal bundle, and quoted from by Mr. Rizdal already. But this judgment dismissed as completely unfounded the decision that Jehovah's Witnesses infringe congregants' right to a private life, and found that community members testified in the proceedings that they followed the doctrines and practices of Jehovah's Witnesses of their own free will. Rizdal, as I said, already read from that decision yesterday, so I won't read again these points. But that same judgment also found there was no evidence to support the allegation that the rights of Jehovah's Witness children had been violated on the ground that biblical texts restrained their independent thinking, hindered the development of patriotic feelings, and made them social outcasts. This same judgment also found there was no evidence that congregants were subjected to psychological pressure, mind control techniques, and totalitarian discipline. More specifically, the court found, and this is on page 2991, paragraph 128 of that judgment. Sorry, yeah, 2997, yeah. Paragraph 128, and I'll read those paragraphs. The Russian courts also held that the applicant community breached the right of citizens to freedom of conscience by subjecting them to psychological pressure, mind control techniques, and totalitarian discipline. On the contrary, the individual applicants and other members of the applicant community testified before the court that they had made a voluntary and conscious choice of their religion, and having accepted the faith of Jehovah's Witnesses, followed its doctrines of their own free will. Furthermore, the petition of several thousand Jehovah's Witnesses to the district court, the president, and the prosecutor general contained the request not to deny them of their democratic rights and freedoms, including the freedom of conscience. The district court considered that all the signatories to the petition had signed it as a result of having been subjected to psychological pressure. However, it was unable to refer to any evidence of such pressure or give an example of anyone who had signed the petition against his or her will. Accordingly, the findings of the Russian courts on this point were based on conjecture, uncorroborated by fact. Mr. Rusdal also made the point from this judgment that the court was unable to find any indication that minors had been lured into Jehovah's Witnesses against their will by deception, trickery, or any other inappropriate means. Likewise, 12 years later, the European Court reached similar conclusions in its more recent judgment in Taganrog, LRO, and others versus Russia. Again, Mr. Rusdal has commented on this decision already, but just two quotations to add, if I may. This is in the legal bundle 4840. And paragraph 157, for the court, it is highly significant that no evidence of violence, hatred, or coercion was adduced in the proceedings against the Taganrog LRO. Both the applicant's religious activities and the content of their publications appear to have been peaceful, in line with their professed doctrine of non-violence. It was not shown that anyone, whether members of the Taganrog LRO or third parties, had been forced, prevailed upon, or pressured into following religious injunctions against his or her will. And down in paragraph 179, continuing in this same judgment, regarding the allegation that the religious community was responsible for destruction of family relationships, the court concluded there was nothing to indicate that the religious organization had made any demands on its members as a condition for continuing their family relationship, or in the other sense, that it had imposed any kind of condition or made any demands on non-witness members of their families or of its followers under threat of breaking up their family relationship. So what does all of this mean? Well, on Thursday, in a question posed to Professor Hadi Lila, Your Honour suggested that if the Norwegian authorities' interpretation of children's rights were novel, it could be that others would follow in Europe. But the reality is that the Norwegian authorities' allegations against Jehovah's Witnesses are not novel. They are a repetition of allegations made by former activist Jehovah's Witnesses in other European countries. And this brings me to the foreign case law section. Disgruntled former congregants are only a small fraction of those who leave the religious community of Jehovah's Witnesses. However, they are zealous in spreading false information in the media and stirring up government institutions to investigate or take action against Jehovah's Witnesses based on one-sided and exaggerated claims. Disgruntled former members then instigate legal action against their former religion. As a result of that legal action, several high courts worldwide have addressed allegations similar to those already raised by the Norwegian authorities. These include court cases in Belgium, Croatia, Germany, Hungary, Ireland, Italy, Poland, Ukraine, the United Kingdom. I'd like to just cite a few examples that are relevant to this particular case. In Italy, and this can be found on the additional legal bundle, page 556. The Christian Congregation of Jehovah's Witnesses in Italy and others. I'm asking, among other things, compensation for damages that he allegedly suffered because his friends in the congregation allegedly ostracized him. The Court of Bari rejected the claims. On appeal, the Court of Appeal of Bari ruled it inadmissible. The complainant then appealed to the Supreme Court of Cassation, which declared the appeal partly inadmissible and partly groundless. In its judgment, the Supreme Court of Cassation concluded, this is on page 558, paragraph 1.4, the conduct of the members who basically refused to have friendly relationships or any kind of relationship with him does not interfere with one's personal rights. But it simply implies attitudes that, although socially reprehensible, cannot be questioned as to lawfulness, since they constitute a free choice, despite it being influenced by religious belief. Poland. A disfellowship person sought monetary compensation for shunning allegedly caused by the religious community of Jehovah's Witnesses. The trial court dismissed his claim. On appeal, the Warsaw Court of Appeal upheld the lower court decision and gave these conclusions. Page 584. Quote from my notes here, when the plaintiff joined Jehovah's Witnesses, he accepted their code, including the fact that the expulsion is final and that there exists a particular conduct, according to the plaintiff's description, it could be called indifference toward the expelled ones, which could be perceived as unpleasant, but not violent toward existing laws. Both the expulsion from the denomination as well as his rejection do not consist of infringement of his personal interests, which are the freedom of conscience and religion. Germany. The Higher Administrative Court of Berlin, in the case of State of Berlin versus Religious Association of Jehovah's Witnesses in Germany, concluded that Jehovah's Witnesses in Germany meet all legal requirements to be granted the status of public corporation, a status equal to that of the two biggest churches in Germany, the Catholic Church and the Lutheran Evangelical Church. Mr. Risdell referred yesterday to this decision. He described the extensive investigation that the state conducted in that case. I only wish to repeat that in that case, the court specifically rejected as unfounded the state's allegation that the religion of Jehovah's Witnesses used the fear of shunning to keep its members in the association by force. That judgment is found in Legal Bundle 5319. And then finally, Belgium. Mr. Risdell quoted yesterday from the December 19, 2023 decision of the Court of Cassation that upheld an earlier decision of the Ghent Court of Appeal. I'd like to briefly comment on the background of that case. A group of disgruntled former congregants filed a criminal complaint against the Christian Congregation of Jehovah's Witnesses in Belgium for allegedly propagating the exclusion policy and teaching it within the local congregations, and thereby inciting discrimination or segregation against former members. In that particular case, the complainants made extreme accusations against their family members, former congregants, and their former religious community. They variously alleged that it had severed their close family ties, it had resulted in total social isolation, and interfered with their free will. The core issue of the complaint in Belgium was the Jehovah's Witnesses' religious practice of avoiding former congregants. The Ghent Court of Appeal described that practice as passive social avoidance. As Mr. Risdell mentioned yesterday, the court found that the religious practice is protected by Article 9 of the Convention. That same judgment also examined the rare situation of a minor being excluded. And it concluded, and this is on page 5408 of the legal bundle, over to 5409, paragraph 2.12.7. It says, as far as excluded minors are concerned, the shunning policy appears to be limited to no longer allowing the minor to actively participate in the daily family Bible study. It is doubtful whether the minor concerned will experience this as a serious ordeal. Furthermore, the Ghent Court of Appeal examined the question of whether there is a general rule to expel those who don't comply with the shunning policy. The court considered relevant parts of the Shepherd book, the Elder's textbook, which are identical to those discussed in this court last week. And on page 5399, paragraph 2.7.3, it states, the manual for congregation elders states, with respect to those who do not observe the shunning policy, use the scriptures to counsel and reason with him. If this counsel is not heeded as desired, it states that he would not qualify for congregation privileges which require one to be exemplary. He would not be dealt with judicially unless there is persistent spiritual association, or he persists in openly criticising the disfellowshipping decision. It continues on paragraph 4. It cannot therefore be inferred from all this that the religious community of Jehovah's Witnesses applies a general and uniform rule that those who do not comply with the shunning policy should be excluded. It would appear that the consequences of non-compliance with the shunning policy are usually less dramatic and manifest themselves in other areas, such as the position that the believer holds in the local congregation. It was noteworthy that the Ghent Court of Appeal during the proceedings also considered statements from family members of the complainants. Interestingly, the Ghent Court of Appeal noted that contrary to what the civil parties or the disgruntled former congregants had alleged, the witness statements of the relatives of those civil parties who remained Jehovah's Witnesses showed there was still some contact with family members. Overview shows how appellate and Supreme Courts of many European countries have dealt with allegations very similar to those by ex-Jehovah's Witnesses in this case. The courts have consistently ruled that the Bible-based religious practice of limiting contact with former congregants is an entirely lawful religious practice protected by the fundamental rights to freedom of religion and association. I'd like to mention that the conclusions of the county governor and the Ministry of Children and Family Affairs are not only contrary to European convention, but also offensive and degrading to every one of Jehovah's Witnesses. In a free and democratic society, it is insulting for the state to disparage an entire religious community, alleging that they're acting under pressure, fear, and intimidation, and that they exercise psychological violence and negative social control against children. And all this on the basis of a few complaints and a cursory look at the beliefs of Jehovah's Witnesses. Deregistration by the state sends a signal that Jehovah's Witnesses are a dubious second-class religious denomination. The European Association of Jehovah's Witnesses, therefore, respectfully, Your Honour, asks that the theoretical rights of hypothetical children, referred to by the county governor, not be allowed to outweigh the actual rights of real young people throughout Norway who have made a conscientious and personal dedication to their God. Similarly, the European Association respectfully asks that the court prioritise the rights of thousands of Norwegians not to be stigmatised for following the Bible over the hurt of a few vocal activists who have successfully exercised their right to leave. To use the words of a former judge of the European Court, history has taught Europeans that the state has an obligation to secure true religious pluralism, which is an inherent feature of the notion of a democratic society. Therefore, public authorities should be particularly careful not to denigrate a religious minority group. Religious minorities already fight a hard battle for survival in many uncompromising political regimes in the four corners of the world. They could dispense with such a battle in Europe. Jehovah's Witnesses have been present in Europe for more than 140 years. They are your neighbours and your colleagues. Their children go to mainstream schools. As we heard in this court, they are computer technicians, company directors, doctors, professors, mothers, fathers, husbands and wives. They come from all parts of society. So to conclude, I would like to quote the Holy Scriptures to indicate what all Jehovah's Witnesses desire. In the Bible book of 1 Timothy chapter 2, verses 1 and 2, it states, "First of all, then, I urge that supplications, prayers, intercessions, and thanksgiving be made concerning all sorts of men, concerning kings, and all those who are in high positions, so that we may go on leading a calm and quiet life with complete godly devotion and seriousness." The only thing Jehovah's Witnesses want is to go on leading a calm and quiet life and to have their religious beliefs and their free will respected. Thank you, Your Honour, for hearing our submission.
Thank you, Mr. Elder.
Thank you.